dealing with here. This bill, it's not about equalizing the playing field. This bill is about helping the big insurance companies to further prevent plaintiffs from being able to obtain any recovery in the courts of Georgia. I would ask y'all to look at the bill for what it is and not to be persuaded by the insurance company's argument in this case. I hope that you can see that in order for the system to work, that there's a fine balance that has to be struck. Our system is working as it is. We don't need to come in with a bill to help.
Gentlemen, I'm sorry, I'm not doing a good job maintaining order. I've got a lot going on, so if you'll suspend just a minute. One more time. There's another speaker on this. There's about 15 questions to this speaker. Please give your attention. Take your conversations to the ante room. Now, if you have pages that are leaving, if you have pages that have got to leave because it's late in the day, I'll take photographs with them, but I'm going to try to do that quietly and quickly. So, gentlemen, continue. And then I'm not going to keep interrupting the speaker. I'm just going to call people out by name if I can't not get your attention. Gentlemen, continue.
Thank you, Mr. Speaker. One other point that was raised by one of my colleagues here on the floor was, and I think it's a good point, is that where does it go from here? You know, there's been a lot of talk about cell phone use while driving, texting while driving, things of this nature. But you know, that's going to be the next thing is, hey, we want to reduce recoveries because somebody's talking on their cell phone while they were driving their car. Now, how many of you, just like me, how many of you drive down the road talking on your cell phone? You may have your own opinions about that, but one thing's for sure, that ought not to be used as a shield for a party who was breaking the law, was perhaps not only negligent, but criminally negligent. It ought not to be used as a shield. So this gives us an opportunity to say we're going to make sure the playing field stays level. We're going to make sure that the insurance companies are held to the same standards that other parties are, and we're going to make sure that if you're injured through no fault of your own, but through the fault of some negligent person or perhaps some criminal, that you're going to have an adequate shot at justice in this state. With that, Mr. Speaker, I'll yield for questions.
Representative Roberts has a question to your right.
Gentleman yield?
Yes, sir.
I was going to ask this question previously, and I'm trying to make sure I'm following this just right. But is it not true that if I'm sitting at the red light and I'm not wearing my seatbelt, and somebody just plows into the back of me and to the side of me, under this bill, they now can use that in the court of law against me when I had no fault whatsoever, but was just sitting there. Is that correct?
The failure to wear a seatbelt?
That's correct.
That cannot be used at this time.
I'm talking about under this bill.
Under this bill, yes, that would be used.
Okay.
Yes.
Thank you.
That's correct. And further, just to sort of amplify on that, if you're in a pickup truck, you know, you've got different rules. And so that's another thing about this bill, as I understand the chairman having explained it, that you're going to be on two different rules for people who might be in a passenger vehicle or who might be in a pickup truck. If you happen to be in a passenger vehicle and you're not wearing a seatbelt, then tough luck. If you're in a pickup truck and not wearing a seatbelt, then the insurance company's not going to be able to use that.
Further yield?
Yes.
One last question. But currently, under Georgia law, you don't have to wear a seatbelt in a pickup truck, correct?
That's correct.
Thank you.
Representative Hughley has a question.
Thank you, Mr. Speaker. My question goes to the fact that we're creating two classes of drivers, the drivers in a pickup truck as opposed to drivers in a car, and we're going to treat them differently in the event of an accident. And if you would speak to that.
Well, that was the point I was just making, and I appreciate that question, is that under this bill, if it passes, then a driver or passenger of a passenger vehicle their failure to wear a seatbelt would be used to diminish or defeat their right to recover if they were injured through someone else's negligence. But if you're in a pickup truck and this bill passes and you're not wearing your seatbelt, then you would have no diminishment or no reduction of your recovery because of failure to wear a seatbelt.
Does the gentleman further yield?
Yes.
Why then would we want to create this requirement when we don't require all of our drivers to wear seatbelts?
And I think that that's a point well taken. That's why we should not vote for this bill.
Representative Reese has a question to your right.
Thank you, Mr. Speaker. Will the gentleman yield?
Well, I don't know, but I guess so.
Well, I appreciate the consideration there. Actually, it's kind of friendly questions. I don't know if I've ever signed on to a bill that after it got changed several times, I'm wanting to vote against. But I see some things in this bill that causes me concern. One of them in the wording on line 16 and 17, talking about evidence that shall not be considered, talking about the cancellation of coverage or increase in insurance rates. Is there anything to your knowledge, legislation, code, whatever, that would cause an insurance company not to be able to raise their rates if someone was found, whether justly or unjustly, not wearing their seatbelts in one of these litigation claims?
Not that I know of.
So they actually could cancel your rate if this expert thought you were not wearing your seatbelt. Is that correct?
Well, according to what I'm reading here in that line 16 and 17, that seems to be saying that would not be the basis. But, the truth of it is, if you're involved in a wreck and there's a lot of different factors involved in that wreck, who knows why the insurance company may cancel you.
That's my point exactly. Also, too, and again, I know you're not the author of this bill, but I wanted to ask this earlier. What about a seatbelt failure? And I don't know what kind of rates there are or whatever. If somebody snaps their seatbelt or whatever and it gets caught on their scarf, and I know some of these guys in here wear scarves, and then the seatbelt comes unbuckled in an accident and it's deemed, well, you didn't have your seatbelt on. Well, yeah, I did.
Right.
It's seatbelt failure for whatever reason. How do you think that would come in play in this bill?
Well, I envision that you do have instances, probably not where the belts snap as such, but where belts fail. And as a result of that, you may be impacted in the chest, you may hit the windshield, whatever. But certainly, you're going to have an insurance company arguing in that instance that despite the failure, they will argue, likely, that there was no failure whatsoever, but you just didn't have the seatbelt on. And it will be, pretty hard to make a distinction between whether or not there was a failure or whether or not there was just no belt being worn.
Sounds like me, sir. It'd be a good day for all attorneys involved in a case like this. And one last question or comment. On line 22 and 23, it seems like it excludes anyone under 14 years of age, even if this bill passes. If you're under 14, I guess it's just tough luck. Is that the way you interpret the bill?
Well, basically what it's saying is if you're under 14, then whether or not you're wearing the seatbelt, that doesn't matter. But the truth of the matter is that if the law is going to apply, and if you really want that to be a requirement, it's like Representative Hughley was saying, it really ought to apply across the board to everybody, whether you're in a passenger vehicle, pickup truck, whether you're 14, 15, 65, whatever.
Lots of questions. Representative May has a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes.
Just for clarification purposes, on page 2 in lines 29 through 32, where it says that if I'm injured or if I'm in an accident through no fault of my own, regardless of, because there's no clarification or specificity on where I might be, if I'm in a parking lot or on the interstate or in the driveway at my house and I'm injured, this potentially limits or completely eliminates my right to recover any damages if someone hits me through no fault of my own. Is that true?
That's my reading of it. I don't see that it's not tied to whether or not that you're on the road or whether or not you're in gear or in reverse that I can